Good evening, everybody. My name is Beth Sykes. I am the teacher in Wenatchee Valley Community Transitions, and we are here today we have Tamara Caldwell-Burns from the county with us, and we are welcoming today Tara Dexter from Overcast Law Offices here in Wenatchee, and she is going to be talking with us about guardianship and other alternatives to guardianship. So for folks in the room, if you want to ask a question, you have a microphone on your table. You'll need to push the little button to turn the light to green. So when you want to ask a question, and when you're done speaking, be sure to push that button again so that the light turns red, or the folks online can hear what's going on at your table rather than what Kara is saying. So welcome, and we look forward to hearing from you.
Hello, everyone. So like she said, my name is Kara Dexter, and I'm not sure where my presentation is going. Oh, okay. And today we're talking about guardianship and other things that are related to guardianship, different arrangements, or things like financial considerations, things like that. Perfect. Okay. And I am an associate attorney at Overcast Law Offices. And my work when it comes to guardianship, I'm usually doing a lot after the guardian has been appointed, helping with more of the administration, the guardianship reports, things like that. And we always give the disclaimer, none of this today is going to be legal advice. None of you guys are my clients as of yet, unless you want to ask any further questions. I do have cards, or if you have anything that you actually want to come into the office and talk to me about, that is always okay. So what I am hoping that we can answer today, and what we're going to talk about, are what's on the board here. We're talking about capacity. What's capacity? What is incapacity? What is guardianship, and when do we need it? When is it necessary? Who can be a guardian and what that process looks like? And then other things like financial considerations, things like ABLE accounts or special needs trusts, and how we can use those to assist in maybe guardianship situations or others. So before we even get to guardianship, if we're considering this, what we're looking at is whether an individual has capacity or not. And this is kind of the broader look. We're not turning to guardianship unless we have a determination that somebody is actually incapacitated and can't make decisions for themselves. Capacity is a legal determination. In general, it's really, somebody can't take in information and make decisions for themselves or care for themselves, whether that's healthcare, whether that's their finances. Incapacity, we see there, we have kind of a bigger definition, but it's if somebody is not able to retain information, process the information to be able to make good decisions for themselves, or even make decisions at all. Maybe they're not able to care for themselves, or they're not able, like I said, to deal with their finances. Normally, in general, every person is deemed to have capacity. There's, exceptions for minors. And even when we're talking about minors, there's different situations when like differences between contracts and healthcare and things like that. But in general, most people are presumed to have capacity unless we make a determination that they don't. So if somebody is deemed to not have capacity, or maybe just in that instance, they can't make a decision for themselves, this is our priority list of who then we turn to make decisions for an individual. The first there is if a guardian is appointed. Usually they are first and foremost going to be a decision maker for that individual. If not, we move down the list to maybe there is a power of attorney that's been granted in that somebody that's acting in an agent capacity for them. If not, we just go down the list here. And this is our list for adults. It's a little bit different when we're talking about minors, but the next we're going to a spouse or adult children. Maybe we're switching that if it's minors. We have to consider parents as well. But this is who we go to if somebody does not have capacity or can't do that decision making for themselves. And then again, before we even get to guardianship, we are looking for other alternatives, because guardianship is actually taking away rights of an individual. They're not able to make those decisions for themselves. We want to explore all options to make sure that there's nothing else that's less restrictive that can maybe solve the issue that we have. And we're going to talk about some of these today too, but that's, supported decision making. Maybe it's just some sort of like physical incapacitation. So there's technological assistance that can help, or like a representative payee, somebody's able to take in that money for you or make payments for you, or like power of attorney, granting that agency. So a power of attorney, this is going to be a less restrictive alternative. And this can only be granted if an individual has the capacity to actually grant it. So we haven't, gone into that realm of them not being able to make decisions for themselves. And there are two, you'll see this in guardianship as well. We split it into two categories: finances and healthcare. So there you can grant agency for just your finances or having somebody help you make financial decisions. You can also grant agency for somebody to help you make healthcare decisions. You can have those be two different people. You can have it all be one. All depends on your certain situation and kind of what the facts are for you. And then you may have also heard the word durable power of attorney. And what durable means is that it's going to survive incapacity. So maybe somebody has granted you agency, they've signed a power of attorney for you to help them make decisions, and then they later become incapacitated. A power of attorney that's a durable power of attorney will be able to still be used after you become incapacitated. So this, again, is going to be one of those less restrictive alternatives before we have to turn to guardianship. But what is guardianship? So the rules and the process is all under the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. And we see this encompasses a lot of things, not just guardianship. But in general, it's a proceeding to determine if somebody needs to be appointed to make decisions for an individual. And like we talked about in the power of attorney, this act actually separates finances and healthcare as well. So the guardian is actually somebody who is helping make medical decisions, and then a conservator is somebody who is making financial decisions for the individual. That could be that it's determined both of those, somebody needs to be appointed for both. Maybe it's the same person. But when we talk about less restrictive alternatives, maybe somebody just needs an agent to make financial decisions, but not healthcare, or vice versa. When we are, there we go. Actually, I think I skipped over one. And is guardianship necessary? Okay, so when we are turning to guardianship, it's when that person is incapacitated. When somebody is not able to make those decisions for themselves, that's when we're going to need a guardian. And the standard that we use is, like I said, it's that legal determination. So it's when the respondent lacks the ability to meet essential requirements for physical, health, safety, or self-care, because the respondent is unable to receive and evaluate information or make or communicate decisions, even with appropriate supportive services, technological assistance, or supported decision-making. So that was a lot of words. There is, the standard is packed with a lot of details, because I'll keep coming back to this idea that we are looking for less restrictive alternatives because guardianship is taking away somebody's rights. So we are making sure that that individual is actually incapacitated, meeting this standard before we're going to appoint a guardian. What the process looks like, though, once we have determined, hey, a guardian may be necessary for this individual. The first thing you do is you're filing a petition. So either the person who wants to be the guardian or who is petitioning to be the guardian is going to file the petition, or maybe it's just an interested individual that sees a need and is going to file this petition. The petition is going to propose who the guardian should be. They're going to propose who the court visitor should be, and we'll talk about what that is. And then also providing supporting documents to prove that, hey, there is a need for a guardianship here. The guardian, there are like professional guardians, and then there's also lay guardians, and that's going to be like your friends and family or somebody who is there to care for that individual, but maybe they don't have training, they're not a professional. Guardians are all held to the same standard, though, even professionals or even lay guardians, they're going to have the same fiduciary duties as a professional. So the lay guardians, you'll see up there that they would be required to take a training, which you can find online, to make sure that we know, what we're doing when we're stepping into that guardianship role. So there are certified professional guardians, and these are people that have actually done training. They are certified. There's usually like a registry of CPGs. And these people, they're typically paid. They're paid for their services. And they might not know the individual themselves, but they're going to have the training on how the process works. So they are experts in, making those reports, doing the inventory, things like that. And they also are more of an expert on their fiduciary duties and when it comes to decision making for guardians. And then again, it could also be friends and family. So a guardian themselves could be somebody's family member, or their parents, maybe somebody who lives with them. And these individuals, obviously, you're going to know more about the individual. So you're going to know more about their needs. Maybe they're more comfortable with you. Maybe they live with you. But again, you're still subject to the same rules as a professional. So that's why we have the training there. Then we move on to the court visitor. So this person is appointed by the court, and they essentially act as like the investigator in the situation. So they are interviewing the individual themselves, the proposed guardians, maybe any medical professionals that are involved, and they are creating a report for the court, and they're making suggestions and recommendations about, whether a guardian needs to be appointed or the extent of that guardianship. The court visitors are also trained. They meet the requirements to be a court visitor, and they're supposed to act like kind of this uninterested third party that's just giving their opinion based on, the interviews and the other information that they come up with. Then there are also guardian ad litems, and these are individuals also that are appointed by the court, and they serve the individual's interest because, again, the guardianship can strip the individual of their rights. We want to make sure that they are fully represented. So the guardian ad litem can step in to make sure that this individual's interests are being represented throughout the process. So we have our petition filed, we have individuals appointed, we've got the court visitors report and recommendations. Then we actually have the hearing on the petition. And at the hearing, the judge is going to be making their determination on capacity, whether the individual does or does not have capacity. They're making the decision on whether the guardianship is necessary and to what extent. Maybe it's not full guardianship. Maybe we're just appointing a conservator. Maybe we're just appointing a guardian or both. And in this, the judge is also making determinations on what rights we are taking away. So this is a list of the rights that can be removed from somebody in guardianship that maybe it's determined they don't have the capacity to do these things any longer or make these decisions for themselves. Getting married or divorced, their right to vote, to enter into contracts, can even be like taking their driver's license away or being able to purchase or sell things. So this is a long list. It's a lot of things that can be taken away. So that is why it's really important that we explore those less restrictive alternatives to make sure that, hey, there's nothing else out there that can be done before we start taking people's rights away. After the hearing, our guardian is appointed and the guardian receives letters of guardianship. And this is something that is given by the clerk. And this is your proof that you have authority to act as the individual's agent. And then also we have deadlines that are set. So there's a few other hearings and a few other requirements that come after. And these deadlines must be followed. There are things like the guardian's plan, inventory, guardianship report. So after that first hearing, we have the petition hearing. There's also going to be a hearing on the guardian's plan to approve that plan. And then there can also be periodic reporting and potential hearings on the guardian's report. So the plan, this is where the guardian's going to lay out their plan for care for the individual, maybe where the individual is going to stay, their finances, we're filing an inventory, approving a budget, what income is coming in, what expenses need to be paid, things like that. This is going to be presented to the court and it has to be approved by the judge. And then after the plan, we would have periodic reporting. These reports could be anywhere from, you have to do it every year, maybe even 3 years. And this is usually where my line of work, I'm usually helping and assisting with this process after the guardian has been appointed. And my biggest piece of advice is if you are appointed to be a guardian for somebody is to keep records. Even if you think it's something irrelevant or you don't need to keep receipts for it or you don't need to write it down, keep track of everything. One, it just makes it easier when you come back to do your reporting, especially if you have something that you're only required to report every 3 years. It may be hard to remember something that you did 3 years ago or a transaction you made 3 years ago. So having records for that. And also if you're having a hearing that you're needing to prove why you did or did not do something, it's really nice to have records to be able to support your decisions there. But a guardianship is not full authority. So there are a few things that guardians can't do. So you can't force somebody against their will to go into a facility, involuntary commitment, things like that. Those are going to be separate hearings to determine if that individual actually needs to do that. And then if you remember the statute that I said where the rules are under, it had a lot of other things other than just guardianship. So when the statute was amended, we added some new things. And I say new, it's not super new, but it was per the amendment. So like minor guardianships. And this one, it could be maybe a little confusing because, hey, if a minor their parents can make decisions for them, but there are certain situations or circumstances where maybe we have an emancipated individual or somebody that still needs guardianship outside of just parents making decisions for them. We also have emergency guardianship situations or conservatorship situations. And this is going to be essentially like appointing a temporary guardian. Maybe somebody is in a situation where there could be, serious harm to them if we don't get them help right now. And we can appoint a temporary guardian just for the time being while we're going through the full guardianship process. And then there's also additions for the protective arrangements or supported decision making. The protective arrangements are they're more narrowed. So it's something that maybe we just have one transaction or one medical decision or treatment that we need an agent to be assigned, but it's not that this person needs full guardianship. This is one of those less restrictive alternatives that maybe we can appoint somebody just to help in this certain circumstance, but we don't need a guardian for, every decision for this person. And then also that supported decision-making or substituted decision-making. This is usually if somebody, they have somebody helping them make decisions, or this individual can access things that maybe they wouldn't otherwise be able to. And this is actually like an agreement between people. Kind of sounds like a power of attorney. And I would say that usually our advice is if you're going to grant any authority to somebody to help make decisions for you or support in your decisions, it's usually best to just grant a power of attorney agency there, because there's maybe some financial institutions that aren't going to recognize certain agreements. They're going to recognize a power of attorney, or it's just more fleshed out where you're granting agency authority to somebody. But this supported decision-making can be something that you make an agreement between you and a family member, you and a friend, and that allows this person, maybe they can see documents that would have been confidential, and they can look at those to help you make decisions yourself. So so the individual is not themselves making it. Then we move into the financial aspect of it. So a lot of times people that are under guardianship, they may also be receiving government benefits like Social Security, Medicaid. And if you are familiar with those, there's a lot of restrictions with what you can or cannot receive to be able to be eligible for these. And sometimes people struggle with even just being able to save and not become disqualified for certain benefits. So there's things like ABLE accounts or special needs trusts that allows you to maybe have a savings or put assets away for an individual for the benefit of the individual. ABLE accounts, that stands for Achieving a Better Life Experience. These are actually like specialized savings accounts for an individual. It allows them to save and invest without risking their eligibility. And then we also have special needs trusts, which is where we're actually transferring title of assets or for the benefit of the individual. So ABLE accounts, there are eligibility requirements. So as you see up there, that the individual has a disability or blindness, that it was before the age of 26, and it has lasted or will last for more than a year, or at least a year, being a U.S. citizen or a legal resident of Washington. And then also confirming that down there, you're either eligible for Social Security income, disability income, you've experienced blindness, or that you can produce evidence of another disability from like a physician proving that. There are restrictions though about what you can use your ABLE account for. So this is where we talk about eligibility or not eligibility, that we can't just, willy-nilly put this money away and then use it for whatever we want. It can be withdrawn, but it has to be used on eligible expenses. And this is the list of expenses that you actually get from the ABLE accounts website. But it's things like living expenses, education, housing, transportation, things that are kind of necessary as your living expenses. The website itself too recommends, you don't have to keep receipts for Washington. They're not going to be requesting that you prove every single transaction, but in an instant where maybe you get audited or the IRS is asking for things, goes back to that. Just keep records of everything so that you can prove or support your transactions that you're making. How you can open an account if you are eligible, you can open it up on the website. So that's WashingtonStateAble.com. And if the individual themselves has the capacity to open it up to themselves, they can do that. If not, if they have like a legal representative or a guardian or an agent or something, they can also open it on their behalf. And then the restrictions with what you can and cannot put into an ABLE account. So you're limited to $19,000 contributions in a year. That's going to be your own contributions and gifts combined. So if somebody is, family member is gifting, they can't gift 19,000 and then you also put 19,000 in. It's combined. In your account, when you set that up, you can put kind of restrictions. If somebody wants to gift, there can be caps. You can set a cap for how much they can gift you to make sure you're not going over that amount. Also, if you're working and you want to contribute to it, you're able to do that. There is some restrictions, like if your employer is also contributing to a retirement account, like a 401k, we can't be doing both of those, but it is there are ways that you can contribute through like your employment. And then the max that you can have in there is 100,000. So if you go over that, it's fine. You can still have that, but then you lose your eligibility for your Social Security income. But once you dip below that 100,000, you become eligible again. So maybe you want to put a bunch of money in that ABLE account and just pay for your expenses through there. That's perfectly fine to do. But once you go above that 100,000, then you are no longer eligible for your Social Security. Then we also have special needs trusts. So there's two types of special needs trusts. There's support trusts and supplemental trusts. And a trust kind of acts as its own entity that you're setting up, and you're actually transferring assets into the trust. Maybe it's a bank account. Maybe you have a house or a vehicle or something, and you're actually transferring the title into the name of the trust. And these can be used for eligibility reasons. They can also just be used for support, but it may be that you're transferring this so that it's no longer in your name so that you can become eligible for things. In a support trust can be used for a lot of things. It may not just be somebody with a disability. So maybe your focus isn't necessarily on preserving your eligibility for benefits, but it's just having something there for your support. So paying for things like your food, your clothing, medical needs, housing. The trust can be set up for that. There are some restrictions with who can and can't access it. The trustee is going to be the one making those distributions for you, and it should be going to your support. Sometimes we call it the HEMS standard, which is health, education, maintenance, and support. We're restricted to those things. We're not just taking draws from it and spending on that on whatever we want. And then we also have the supplemental trust. So the supplemental special needs trust, these trust accounts, they're more restrictive to ensure that we are remaining eligible for any of our other government benefits. And supplemental, that means that it's supplemental to our government benefits. So usually those programs are designed to pay for certain things. The trust should only be paying for things outside of that. And the other requirements to make sure that we remain eligible, the beneficiary, they can't have a say in where the money does or doesn't go. There's going to be a trustee, a separate trustee that's appointed, and they're the ones that are deciding the distributions. And then there's also restrictions on things like what the distributions are going towards, and it has to be, irrevocable. So the beneficiary doesn't have the ability to change the trust or get rid of the trust completely. And then you'd also see that bolded down below, specifically in the special needs, the supplemental special needs trust. This one here, it says first party. So these ones, there's also going to be a third party that I'll talk about, but both of these trusts, there's terms in there that say, how the distributions are made, what it can go to or can't go to. And then down there at the bolded, that any funds left over once the person passes away, that has to go pay back any support that the state paid for. But the first party special needs trust, this is just a designation that says it's funded by the individual's assets. So maybe they had, a house, they had bank accounts, they had whatever other assets, and they're transferring it into the trust. And this could be for eligibility reasons. Maybe if they aren't eligible because of the assets they have, they can transfer it into a trust. There's a lot of restrictions and exceptions with that, but that's kind of in general. And these, what you'll see there, same thing that we talked about, it has to be irrevocable. They don't have the ability to change it or determine what distributions are made. And then we also have third-party special needs trusts, and this is where it's funded by somebody else's assets. Maybe it's a family member, a friend who's creating this for their support, and they're putting their assets into it or transferring their assets into the trust. It's going to be the same type of restrictions. It's just that distinction between whose assets we're actually funding it. And same thing here, that the trustee, they're the ones that have the discretion on what it's being used for. And then the beneficiary can't change anything. And then the other restriction there is what it is being used for. So usually we like to bake this into the trust to make sure that none of these rules are being broken, but it is supposed to supplement our government benefits. So this is the list that actually comes from like the Social Security rules, what we can use special needs trusts for, things like clothing, your phone bill, internet bill, household goods, education things, other like medical supplies that aren't already covered by maybe Medicaid or any other government assistance. But what it can't be used for are things that those government benefits are supposed to be paying for. That if you dip into that area, it could make you become ineligible for that. They look at things like if you were to go buy a house with the trust, they see that as an in-kind or in-kind fund. So maybe it's not an actual distribution that's going to you. You're not getting money, but you have something similar to housing. And then also we can't just make payments directly to the beneficiary. That's looked at as income. So you can't just cut a check for the person and say, go buy whatever you want. That would be outside of the trust. It's now considered income and it can affect your eligibility. So I believe I kind of cruised through that. So what questions do you guys have, if any? Perfect. I nailed it.
Okay, so do you guys offer like free consultation? Like that was a lot of information to take in
Yeah.
and like based on our own specific situations. Like, do you guys kind of point us in the right direction? Because I'll be honest with you, I'm lost. I was right in.
Oh, sorry. I know. I kind of zoomed through that. And what I can do too is, I don't know if like anybody's sending out emails after this, but I can also give you links to the slides if you want.
Yeah.
And I don't believe that our office does free consultations, but I do have cards. And if it's something that you have like a question on it, definitely we're here to help. So yeah. And I don't know if I have the ability to or if we have the ability to send out the slides to everybody who attends, but I know it's a lot of information and there's some links in there to the websites that are hard to take down when you're when you're in the presentation. Yeah. Yeah. Perfect. Perfect. Yeah. And my information's on there as well too, if you want to just reach out with questions. Anybody else? I know that was the most exciting information. Yeah.
I got a couple.
I have a question.
Sure. Go ahead.
Does Washington State special need do they have any reciprocity with other states?
In like what aspect? Like if
If you had a like a guardianship in Washington and you move to another state,
mhm.
would you have to have it redone in that new state, depending on the state?
It's going to depend on the state. So, you know, a guardianship, other states should accept like the letters of guardianship that I was talking about that you get in the beginning, like when you are appointed a guardian. But if you maybe move residency and you become a permanent resident in another state, or the individual does as well, there may be some other laws there that require you to do a guardianship there. But essentially, your authority is something that should cover wherever you're going to go. If you maybe are on vacation somewhere else, you know, your authority is still going to work in another state as well.
Okay, thank you.
Yeah.
So one question is, when you're keeping records, are bank account statements enough, or do I need the receipts for the individual items?
That's a good question. For the most part, bank statements are very helpful because usually it's going to list what that transaction or where it went. But if it's something that could be questionable, or maybe it was that you just drew money to go pay for something, we're wanting receipts for that. My lawyer answer is to keep as much record as you possibly can. But if it's just something that, you know, hey, it's in the bank statement, but I didn't keep the receipt, it's probably okay.
And then I'm wondering, where does, what kind of trust is the Washington Endowment Trust? What version is that?
That's
you
a
described.
great question. Washington Endowment Trust, is that like a? Okay. I actually don't know much about that one. I would have to look into that and see how that would play in with those other accounts and like special needs trusts and stuff. Yeah. Any other questions?
You have a question? I told. But my oldest or my son wants to attend a college program called Roar. And when we started talking to some other parents who their children have done that, they said you can't have guardianship. It limits that they won't be able to attend the program. Do the things like the durable power of attorney and supported decision making, does that limit their ability to I don't know how to say it right, like, well, you know, how is that gonna be different? Why, I mean, I don't, you might not know why he can't access if he has guardianship, but is it I know it's less restricted. I can't think
Yeah.
of how to ask that question, but you know what I mean?
Yeah.
Yeah.
I think I kind of understand that, guardianship is essentially you're stepping into that person's shoes and actually like making the decisions for them. Whereas a power of attorney is that individual is allowing you in certain circumstances to either help them or to go do it for them, maybe because they physically can't, they just can't get out of the house to go pay a bill, or maybe in that moment they can't, maybe they're in a surgery or something. And the power of attorney is less restrictive because it's supposed to only be, based on what the individual wants or has actually told you to do. Whereas guardianship, you are actually making the decision for that person. And I'm not familiar with the ROAR program, but it could be because after a guardianship, they're usually deemed incapacitated, that maybe they just don't have the ability or capacity to enter into the program or do whatever that program is requiring. But I'm not familiar enough to know that. But it probably would be if you had a power of attorney, it's going to be less restrictive. Yeah. Anything else? Yeah. I know, yes. I know I kind of zoomed through. Yes. Anything else or if I need? Well, obviously you guys will have this slide. Yeah. Links or anything that need to be sent, but I think all the information is in there. Yeah, that's one. I didn't think about that either. I did that before and I should have probably just had it. Handed it. Yeah. Perfect. Well, thank you. Would you like some pizza?